Hi everyone, this is Ramanuj here from LawSikho. I am CEO of LawSikho, and I have been having Komal is a co-founder of mine, and I have had many co-founders over the years, and 3 different startups so far, and all bootstrapped. I never raised money, but we are profitably bootstrapped, doing multi-million revenue. We did around 20 crore last year in revenues. But I must tell you that you know I have experience in 2 ways about co-founders agreements. One is I started I am by training a lawyer, right? I went to law school, and then I worked in a big law firm for 1 year. And during that time also I came across, and I was working in PE investments mostly. And at that time I saw co-founders agreements and understood it. But I have been working with startups from when I was in college, and I saw that most of the time startups failing was because of co-founder disagreement and co-founder fights. How many of you good gentlemen and ladies had your previous startups shut down by co-founder disagreements, or maybe it didn't shut down but there were real existential threats? And maybe it is happening in your current startup, because it's very well known that co-founders not being able to work things out is one of the biggest reasons why startups shut down. And if you have co-founder conflict, if you have co-founders who do not gel well together, there is no chance that you will succeed as a startup, because it's like trying to climb Mount Everest, while you have, like, I don't know, like your leg is being cut off, right? Somebody's sawing your leg, cutting it off, and you're trying to climb Everest. What will happen? So before anything else, let's do a quick check. Komal, do you have a poll or something that you can launch? Who are with us? What do you guys do? Tell me in the chat also, like, are you a lawyer, law student? Are you an entrepreneur? Are you a CS? I don't know. Or you're planning to start a company soon. We have launched the poll, respond to that, but you can also introduce yourself in the chat and say hi to everybody else as well. Okay, it's really nice. There are 90 of you almost have responded to the poll, and 60% are founder of a startup, 4% are senior executive in a startup, 18% planning to start a startup soon. And I see there are about 11 lawyers, CS, CA. There's one HR manager. Wow. You must be a really diligent HR manager that you are here to know about co-founders agreements. I am glad that you are here. Like, more HR managers should do it, but mostly they don't know anything about these things. You have an interest. I congratulate you. And there are like
I think Ramanuj's video has frozen up. Yeah, Ramanuj, I think you were frozen for a little bit. So
I had a famous Gurgaon power cut.
Yeah.
Now I'm using my mobile. So anyway, so I hope I'm visible and it's not too dark. I don't know. Am I visible? Cool.
Yeah, you are visible.
Okay. Cool. So where was I? So basically, yeah. So I was talking about who are attending here, but very sad that there are, I see 145 people here and 115 have replied to the poll. So if the rest of you will also reply, I would be very happy. It would be really nice. And a lot of people are introducing themselves in the chat. Sharath, founder of FitBaby. Dolly Vasin, planning to hive up a division of my company. Great, awesome. So many great people are here. Yatish, Shubham. Awesome. So many of you, right? So coming back to the discussion about co-founder agreements, right? So first, let's talk about what is a co-founders agreement, right? Anybody has any idea what is a co-founders agreement? Let me see. Tell me in the chat whatever you think of what is exactly a co-founders agreement. Nobody is saying anything. A lot of amazing people are here. Hi Bhuvnesh. Hi Gaurav. Well, what is the co-founders agreement? A shareholders agreement to govern decisions and powers. Very good, Mohit. Almost absolutely correct. It's correct. It is an agreement between the initial shareholders. Normally, you actually do a shareholders agreement when you have transactions, right? So if you raise an angel investment, or definitely if you have VC investment or whatever, you will be entering into a shareholders agreement, right? Or a share purchase agreement. But if you're a co-founder, you don't purchase shares, it'll be shareholders agreement. But there is one, when you are starting the company, right? Nobody actually signs a shareholders agreement. There are foundational documents of the company. Of course, there is memorandum of association and article of association. And when you incorporate your company, you can put your co-founders agreement as a part of the article of association. You can incorporate it there, right? But most of the time, if you go to a CA or anybody who incorporates a company, incorporation services, so many are there, they will not spend too much time on your article of association. They will simply say, you know what, I will put the standard form, article of association, they'll use standard form, and that's it, right? And that does not work for startups. Okay. That is one thing. Second thing is that even before it goes to incorporation, right? Maybe there are a few of you who have come together, maybe two friends decides that let's make an app. It's not like the first thing they do is go and incorporate, right? That won't even make sense. Maybe it's just a project, correct? And you start working on it. And incorporation is too much. Like, it will be like a lot of, there's a lot of things to do before you incorporate a company. And you may not want to incorporate a company on day one. But you have co-founders, you have a relationship with them. You can document it in a co-founders agreement. And when you incorporate your company, remember to give this co-founders agreement to whoever is incorporating, CA, CS, lawyer, give it to them and tell them that please incorporate these terms into the article of association. Very important. Remember this. Now, this is the co-founders agreement. It's an understanding between the people who are starting the company, the co-founders, right? Very simple as that. And why is it different from a shareholder agreement? Because you can call it a shareholder agreement when you have shares. That is when there is a company and there are shares. In the beginning, when there is not even any company, and obviously it is important even then, because even before the company comes into existence, that you have some understanding about all the activities that you're doing, and then you sign a co-founders agreement. Now, before we go and discuss what should be there in a co-founders agreement, that we will discuss today. But the first I wanted to think about what happens if I don't sign a co-founders agreement. I have heard from a lot of people, they say that, I have started a company with my brother. I have started a company with my best friend from college. And we have such great understanding that we do not need a co-founders agreement. How many of you great people here think like this? No agreement is needed. I am doing this with my wife. I am doing this with my brother. I am doing this with somebody. We are like such close friends. There can never be any difference like this. Okay. Some of you are saying that, yeah, I have used to think like this, already done this. Sorry, I wish I should have done this before, but I was not there to tell you, warn you beforehand. But I wrote an article long time back. You should have Googled and read. But now that you haven't, you have suffered already, you have learned better, you are going to sign a co-founders agreement. But before that, let me make it even more clear to you by telling you first my own story, second, another friend's story, and third, a true horror story. So my own story. So, the first company I did, it was with my college best friend and my girlfriend, right? So very good, right? Like the two people that you like, of course I can trust with eyes closed, right? But as you can guess, like 3-4 years went very nicely and we were making money. We were making 30-40 lakhs per month revenue. We have that time maybe like 30 employees, and things are going good and looking bright for the future. And what happened is that one of the people, I was not very happy, like she's a co-founder, so I'm like, you need, and she was in charge of sales, and sales was not growing, and we were having disagreements about it, that why is sales not growing, and she's like, no, I'm working my best, and she was not even the right person to take sales forward. And then she one day comes back and says that I want to go on a sabbatical, I can't take this anymore, and she goes on a sabbatical, comes back. When she comes back, by that time I am not willing to work with her anymore. Like she comes back and within 1 week we're clear that it's just crazy, right? It's like I was like, I can't take this company forward if I have to deal with so many objections on every day. Like we can't agree on anything at all. Complete breakdown, right? And the 2 months she was not there, we made real good progress. And when she comes back, it's like, oh my God, we are not making any more progress because we can't agree on anything anymore. And on top of that, so we said, okay, fine, we will work this out, whatever. And then at some point we said we can't work together. And then a lot of problems started. But good thing is that we were lawyers, we knew about it, and we signed a co-founders agreement when we started. Now, because we had a co-founders agreement, it was clear that what is to be done in such a situation when we are not able to agree on how to proceed forward, or somebody has to exit. And then she one day said, I want to exit the company. What can you do? And we agreed on a bunch of terms and we signed that and all of that. But everything was easier because everything was written down how to deal with it. And even with my current co-founder, Abhyuday, and I know he won't mind if I share this, there was one time and this is when we are even a bigger company. We are having like, I don't know, about 1 crore of revenue or something per month. And we had a huge fight. Right? And it was like, we can't work together anymore. Right? But it was written in the co-founders agreement, how it will happen from there, right? What is my right? What is his right and everything. And then, so the arguments that were happening, there was a framework. We could not be unreasonable. We had to follow that framework, right? And thank God we had a co-founders agreement that we were able to come to terms. And then we agreed, then we solved the differences. And after 1 week, we're back working together as usual. And from there, we have grown a lot even since then. And this was like 2-3 years back. Now, my point is that having a co-founder, like this is a person, my best friend, Abhyuday is still my best friend, my co-founder. Even today, we really love each other and great relationship, right? But having the agreement saves us from just trusting the other person. It's like, our friendship is stronger because it is not strained by the lack of an agreement, because all the understandings are documented in the agreement. It makes our friendship and relationship easier. Okay, I'll tell you another story. I saw, this is a junior who started a college, a company when we were in college. 7 people together started this company. Right? 7 people together started this company, all co-founders. Now, there was only 2 people who was doing any work. 5 people worked for 7 days, 1 month, I'm not sure, 3 months, and then all like, everybody's happy. There was an Economic Times article where they are all named and their photos together. Students from NUJS launch amazing company, and everybody's happy, satisfied. 5 people stop working, right? And they not stop working, they work. Like one day they will move one needle or whatever, right? So, but everybody else, like the other 2 people working very seriously, right? Especially one person working really seriously. That person doesn't do anything. All day he does this only, this startup only. Now, everybody's like, but we should get equal shares. 7 people, completely different involvement, saying we should all have equal amount of shares. The guy who's working is like, My God, why will I do all the work and you guys will take all the benefits? This is not possible, right? He is not agreeable, obviously. So this thing, there was an argument that went on for a long time, I think 6 months. And during this 6 months, the startup went to dogs, right? Because nobody wanted to work on it anymore because everybody's unhappy. The 7 co-founders fighting. Okay. So finally, what happened is that all the other 6, the other one person left completely, said, I don't want anything of this after so many arguments. 5 of them got 10% of the equity on some day that they will do this much, whatever. So they didn't get 10%. They got total 10%, 5 people, 2% each, and the rest of the company with 1%. Finally, this was decided. Now imagine if they could not agree, the company will shut down. Nothing could be done. Another horror story. Another friend of mine made from many years back, and he told me he has a startup. This is a manufacturing startup. Now see, all these online websites and all still manageable, right? These people started a manufacturing company with a manufacturing unit, startup, but a manufacturing unit is involved. The manufacturing unit, there is land, they have taken loans, and they did not have a non-compete agreement, right? So these 3 people, they had article of association because they had incorporated. They got loan from the bank. They have given their own personal loans. 3 people, 3 co-founders. One day what happens? One co-founder says that this is very nice, but I am going to start another manufacturing unit alone without you guys. And he starts it, same business. He starts the same business. Another manufacturing unit. He had enough money. He just went and started one more. And competing with the same business. So that guy is a shareholder here in this company, running another same business 10 kilometers from here. And the other 2 co-founders are like, what the hell? How is this fair? Okay. And I said, I had told you, sign a co-founders agreement. And they're like, no, this was my brother. I trusted him. I said, okay, no problem. What to do now? Now try to sign an agreement with him or something. Figure it out how to do. It's really bad, guys. So if you do not have your agreements clear, and especially with your wife, with your brother, with your sister, with your mother, if you do business, even more important that you sign a co-founders agreement so that your relationship is not strained, because you have a written document which says what to do in what situation. That means if there is a conflict, you can go to the document and see this is written here. We'll do this, what is written, not something else. And then you can make concessions. You can be the bigger person and say, okay, it is written in the agreement, but chalo, I will do some concession for you. Nobody will stop you from doing that. But if you have nothing written, then you have nothing to go by, and there will be no agreement. There will be huge fights. Okay. Now, this is why you must sign a co-founders agreement. Anybody else has any better horror story? Maybe you can share in the group or anything else. Somebody saying, how can I share invite to this meeting? You can just, somebody wants to invite their
co-founder. Shared a Zoom link as well after that. So you just directly share the link.
So somebody is realizing that we need a co-founders agreement, and they don't want to tell their co-founder. They will bring them here in this so that they get convinced to sign co-founders agreement. Very smart, very smart. Okay. But yeah, it's true. A lot of co-founders are afraid of talking about signing a co-founders agreement. It's like people are afraid of signing an agreement before marriage, prenuptial. Prenuptial agreement is like, in case we get divorced, how the property gets divided, right? So people don't want to sign that before marriage. They're like, oh my God, and all of that. And people, look, if you are having a co-founder with whom you are afraid to discuss a co-founders agreement, you already have a big problem. This is a red flag. I am not kidding. If you are afraid of talking about, look, we should sign a co-founders agreement, you cannot talk that to your co-founder. You already have a big problem in your hand. Okay. All right. So nobody is telling any horror story. So I think we'll proceed from here, right?
Yeah,
Anybody who is not fun,
I
you
can
want to
share
share?
one that recently happened with a client,
Yes,
and
yes, yes.
this is like a very fledgling e-commerce startup, and there are four founders. Right now, two of them are already carrying on some another business, right? And they are contributing specific skills to this, and two of them are full-fledged co-founders. They are giving all their time, all their efforts to the business, right? So what happens in this case, and this is a very fledgling, like just started, they just have their site set up, they just have their domain name, they just have like, started out into everything. And then suddenly one of the co-founders is in this zone that this is a tech company. So I am the tech person who is there. So I'm doing everything. Like I'm kind of doing everything around here. What are the other people really doing? Because it's like, all the tech part, all the portal and everything I'm taking care of. So I want to have like, this much salaries, and it's an unaffordable amount totally for the company to, agree at that point of time. So obviously the other co-founders try to tell him and try to reason with him and say that, look, we don't even have so much business at the moment, we are only growing, we are only trying to get something, so please understand, like this is not the kind of salary that the company can do at the moment or afford at the moment, and you are a co-founder, you are holding equity in the company, so that's kind of your take into it. But this guy kind of doesn't isn't willing to reason, is not contributing time, consistently creating problems for the other co-founders. And here also there was a specific, they did have a co-founders agreement, and they had a very specific situation of what is going to happen if if someone doesn't perform, stops performing, starts creating trouble. They had very clear guidance on what to do in this respect. So they were able to proceed because of that, and reason with him because of that, that look, this is what is provided for, and this is how we are going to act. But in the absence of it, it would have been very difficult for them, because this was the guy who had, like, all kind of held all the IP in the company with the portal and everything. So it would have been very difficult if the IP had not been provided for, if it had not been provided for, that if people stop performing, what happens? Like he could like totally claim that all of this is my IP. So it's just one another horror story that I came across.
Good. Very good. So let us talk about now let's get to discuss, what exactly happens and what kind of clauses that you need to actually have in the co-founders agreement, and what are the important things that you want to address in your co-founders agreement without fail. Okay. So before I start telling you, anybody wants to share, what do you think are important, should be that should get covered in a co-founders agreement? From the horror stories, you already know 2-3 things, right? So tell me 2-3 things that you should be having. Hey, how many of you actually have a co-founders agreement? Since there are like at least 120 co-founders and people who are planning to start, etc. How many of you already have a co-founders agreement? Just write I have one, or I have, or whatever. Or if you don't have, write don't have. If you have it, write have. Oh wow. So most of you don't have a co-founders agreement. No, naturally, if you have, why will you come here? But if you have it, you can still want to modify it if certain things are not there. So even if you have a co-founder agreement, it's not like a it's not like, I don't know, it's not like land, it's not like property. You can still improve it, and you can make sure if something which should be there and is not there, you can now put it by discussing with your co-founder, right? So you can put it there if something is missing in the co-founders agreement. So let's discuss. So Somebody saying, I don't have a co-founder only. Lucky you don't have co-founder, no problem. But if you ever find one, then you will use this, right?
Yeah, people look for co-founders, like even look for co-founders as outside externally, like people advertise and say that we are looking for a co-founder with investment. So it's not like, it is only people who are in the relations. Usually that is the case, but like nowadays you see people even openly looking out for co-founders and things. So
great, super. So what do you think should be there in a co-founder agreement, which you feel is very important? Ownership structure. Ritu is saying ownership structure, confidentiality, management. What management? How to manage? Somebody saying, is the agreement notarized or registered? You can register it. Notarizing any document does not help much. By the way, let me enlighten you. Do not notarize your agreements. It does not help. Okay? It's like band-aid on, you don't even have a cut and you're putting a band-aid and everybody thinks, oh, something. Where it's really, there's no legal sanctity to notarizing your document. Please don't do it. Useless activity. You don't need to register a co-founder agreement. You don't need to register a co-founders agreement. Okay? You can register if you want. It is not compulsorily registrable. It's optional registrable. You can register if you want, but not necessary. Okay. So a lot of you have said different things. Non-compete clause, exit understanding, very good. Muhammad Abdul Naim. Is it legally valid? A co-founder agreement, if executed in a valid manner, will be valid. Role and responsibility, very good, Chandan Raj. Rohan Bandekar is saying shareholding exit clause. How to get a new founder and how to fire a existing founder. Very good. Okay. Arbitration clause for dispute resolution. Sumit Kansal, good. Economic interest and ownership, good. So you guys are very good. You guys are very smart, already giving the correct answer. What if the co-founder is abroad? I have never seen this clause. But okay, you can always create new clauses. How to induct new co-founders. Very good. So yeah, you guys are right. All of these clauses are necessary, right? But I'm not going to talk about all the clauses that are there, but we are going to give you, are we doing some, Komal, giving people some this thing? Are we giving them, what do you call it, templates of shareholder, of co-founder agreement?
We can share in
We will give you, yeah, we'll give you a co-founder agreement template with some advice.
We can share it.
We'll share it in the end, but hold on. Okay, so you will see all the clauses that will be there. And some of you are already thinking that I am going to use this template and I don't need a lawyer anymore. Let us just warn you that I wish that was true, but it is not. But we'll come to, let us start understanding the issues. Okay, what are the issues? First, non-compete. Very good. I want to talk about non-compete clause, right? Non-compete clause is very important. This is a very basic clause. If people are working in your startup, you do not want them to go build another startup with the same business. That's just crazy. That is insane, right? No startup can survive that. Intellectual property, because same thing. Now, intellectual property. Imagine that you and I start a startup, and I am writing code, and you are doing sales. For example, right? It is very important that the code that I wrote, that belongs to the company and not to me, or belongs to the joint, whatever entity you are creating, or it belongs to us both. And the sales I bring, the money goes to both of us and to the entity, not ideally just to me, right? Exact same thing. So you need to address IP issues as well as non-compete issues. Very important. Okay. And we are going to give you a template where you will see what a non-compete clause looks like, what an IP clause looks like, right? But ideally, it will be written that all the work and any IP that you are generating, any work that you are doing, is automatically assigned to the new venture, new entity. Okay. Very important. Okay, what other clause that is critical? Non-solicitation. Non-solicitation is that you will not solicit employees of the company or other co-founders of the company or clients of the company and take them to another business. Non-solicitation. Got it? Very important. Right? You don't want one co-founder to leave someday or without leaving, start soliciting on behalf of another business, right? That will be very problematic or not? Will that be problematic? Yes. So non-solicitation is another important clause. Of course, shareholding pattern, to you'll agree and you'll write if any of the shareholders or any of the co-founders are bringing any capital, if you are going to invest some money, then that should be written. If you are going to put in some hours of work, you have some kind of understanding that, okay, we will both work 4 hours per day on this venture until we reach this much revenue or whatever, until we have a working product. There may be some, or we raise our investment, there may be some landmark that you have decided that, okay, if we do this, then we will start working full time. All those things, all those understandings need to be written down in the co-founders agreement. And it also needs to be written what happens if the other person stops doing work. So for example, if I have promised that I will work for 4 hours a day or 6 hours a day or full time, if I stop doing that, then what happens? Do I lose my shares? How does it happen? Do the other parties get an option to buy my share back at a certain price? Multiple options are there, but it has to be decided. And vesting is another option, right? So what you do is you have a vesting schedule that shares vest in you. Let's say I'm going to get 20% shares, but this will vest over 4 years. So every year I get 5% shares. And there is a concept called cliff. What is a cliff? Do you guys know what is a cliff? Cliff is that you can write in your agreement that if you leave before 2 years or 5 years, or you are fired before 2 years or 5 years, then you will lose all your shares in the company. You will not even get those shares. So cliff is like, imagine a mountain cliff, right? And you can fall off. You don't get any shares. Okay. Amrita is saying unable to understand you. Can you guys hear me? Am I audible?
Yeah, you are audible, Ramanuj. You are visible also. Like,
let the other people who are watching clarify.
Let's see.
I am requesting the audience to tell me in the chat if you're able to hear me, if you're able to see me, if it is all good. Okay, audible and visible. So let's continue. So very simple thing, cliff is very important, right? So you have a vesting schedule and you have a cliff. Vesting schedule says, okay, every year you get 5%, but if you leave before 3 years, you get nothing, zero, anda. So that is cliff. So you have vesting and you have cliff. Very important clauses. What are the other important clauses? Always remember, very important is exit and firing. Under what circumstances can you fire a co-founder? If a co-founder loses sanity, becomes insane, can he be fired? If he goes to jail for 3 years or whatever, goes to jail for 6 months also, can you fire him? Okay. If a co-founder goes bankrupt, can you fire him? So what are the circumstances under which you can fire a co-founder? If a co-founder stops working or contributing to the company, can you fire him? How much share will he retain in that case? Will he retain anything? All of that. So very important. So expelling a co-founder, removing a co-founder. Okay. Sometimes they'll be removed from the company, but still may retain some shares, which is okay, right? Sometimes you're okay with them retaining some shares, but you don't want them to be part of management anymore because they have done something, right? What if they steal money? What if they commit sexual harassment? What if they do something else in the company? Say they participate in an embezzlement. They submit false invoices. What will happen? these things should also be covered in your co-founders agreement. How many of you have co-founders agreement that don't deal with these issues? Do you have it? Have you addressed in your co-founders agreement? Very important. Okay. Now another question is, how do you bring in new co-founders? Okay. So let's say we want to induct a new co-founder, and you have to decide, will it be based on consensus that all the co-founders have to agree? Is it going to be the basis of majority, that if a simple majority of co-founders want to induct the new co-founder will be inducted? Is it a special majority, two-third majority, that two-third of the co-founders have to agree to bring in new co-founders? Only then that is possible. So these things you can write down in your co-founders agreement, and whatever you have written will be final, right? That can be used to make decisions. So this is one part of it, right? Another part, which is very, very important, is management. How will day-to-day decisions be taken between co-founders? And many of you are asking that, first question is that who will be CEO? Now you don't write in the co-founders agreement who will be the CEO. But it is actually something that determines who is going to be the CEO. How? So how are decisions made in a startup? That is up to you. It is your startup. You can decide that we will make decisions this way or that way. And you can decide that decisions will be made based on majority. So people have shareholding, right, in the company. So certain things are given in the Companies Act also. But it is better to write it down how you want to do your governance. So what happens is that the CEO is appointed by the majority shareholders. So if the majority shareholders decide to appoint one person as a CEO and the minority shareholders are not agreeable, they can't do anything, right? It will be by a majority, except unless the agreement says that on such a matter, one or two or every co-founder will have a veto. So you can say that co-founders, I may have only 10% shares. I cannot decide alone who will be the co-founder. So, who will be the CEO, right? But if I have a veto on this matter, that before deciding on a CEO, my written confirmation has to be taken. If I say no, you cannot appoint that person as a CEO, that is possible to be written in your co-founders agreement. Whether it is a good idea to write that in your co-founder agreement is a different thing. I don't know about that. That is between your co-founders, right? You know your dynamics better than I do. But you have an option of doing such a thing. If you don't do it, then it will be decided based on majority shareholders. Clear, everybody, how CEO is appointed? Okay. Is my voice fluctuating or is it like properly audible? Somebody saying my voice is fluctuating. My voice is fluctuating.
It was for, I think, very few seconds it fluctuated, but then now it is back clear.
Some people are saying clear, some people are saying fluctuating. I'm confused. What do I do? Okay. If you guys can't hear me, I can change the internet connection. Wait. I hope it will be better now. Okay. Somebody is asking me what am I drinking? I'm drinking kombucha. It's not alcohol. Okay. For the records. Okay. So coming back to the discussion. What happens? So these are some of the important clauses, right? So remember, there are some very basic things. You don't have to remember so many. You don't have to remember each and everything. Something you have to remember is that number one is that how do you bring in and kick out co-founders? This is a very important thing to decide, because you might have to bring in new co-founders and you might have to remove some co-founders from the system. This is very important. Second, you definitely need a method, like your commercial understanding needs to be captured. What is the commercial understanding? Who has how many shares? How much? What do you bring on the table? Do you bring in capital? Do you bring in work? Do you bring in connections? Whatever it is, right? That, and what happens if you don't bring that? That needs to be clarified. Very important in the co-founders agreement. Third is that third thing is related to ethics. That you will not do anything against the interest of this company. There will be a number of clauses which will take care of that. That you do not do anything. A startup is like a baby. We are all together creating this baby. You are not going to do anything that will harm this baby. Those clauses will also be there. Okay. So so this is IPR also is a part of that. That whatever you're creating is going into the company as IPR. Without that, you can get into big trouble. And exit. How do you leave? In good terms, in bad terms, how do you leave? If somebody decides that I don't want to do this startup anymore, I want to go get a job, or somebody decides that I am not able to gel well with all these co-founders, I want to go start something else, I want to work in a different company, I want to do another startup, whatever, I want to do a job. How do you exit? What do you get when you exit? Okay. All right. What else is there? And there is certain kind of clauses which is about minority protection. So if you are a shareholder, you want certain protection, that certain things should not be done without your consent. For example, the company should not change its line of business without your consent. Company should not take out a huge loan. Let's say any loan above 10 lakh rupees, it should require your consent. So you can put in veto powers of the co-founders, that even if others agree and I don't agree. Or selling, in what circumstances can you sell the company? In what circumstances can you raise investment? All of that you can also put veto powers. But remember, putting veto power is dangerous, so don't put too many veto powers. It can lead to problems later on. Okay. And how to make management decisions, which is done through the appointment of CEO, COO, etc. So shareholders can appoint office bearers of the company, or decision makers in the company will make decisions, right? But shareholders can also fire them. That power is there with the shareholders as per Companies Act. But you can still rewrite that in your co-founders agreement if you want, how such a firing takes place. Okay. Okay, so these are the most important clauses. Now I am ready to take some questions. I'll take at least 3-4 questions on. You have other questions about this, happy to answer, right? And I know there are many questions coming to your mind at this point, and you are thinking, what if that situation happens? What if something else happens? Those are valid questions you can ask now, and I'll be happy to answer those questions. Komal, do you want to talk about 1 or 2 clauses that really comes to your mind that you have recently dealt with, or something that has become an issue? And of course, there are boilerplate clauses, right? What is the country of this agreement? What law applies to that agreement? What will be arbitration clause? There should be an arbitration clause. What will be, there are many things, right? So bunch of boilerplate clauses also go in, confidentiality and blah, 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 blah. Yeah, Komal.
Yeah, so see, many clauses are many clauses are affected when you are bringing in a new co-founder, because there are already some people who are then there, and again that balance or that decision or the decision making mechanism, ownership mechanism, everything changes when a new co-founder is brought in. Okay, and especially when that person is putting in capital into the company. Now, many people are looking for co-founders with investment. So when you bring in people who are going to put an investment in the company and are going to become co-founders, then there are a lot of things which need to be taken care of. For example, I have come across one place where there were 2 co-founders who were very they've been there since long time working together and have started a new business. But what they lacked is IT skills, right? Now there's another co-founder who they were seeking and who is joining in with investment in the company and who is also going to be the CTO, basically, right? So he is going to handle the tech aspect of the company. Now there is confusion among both of these people that it is kind of two groups inside the company, that these two who were already existing and who have already put in a lot of effort, and this new person who is going to join in, who is looking to look at the tech front. But how will his shareholding shape up? So when you are admitting new people, or there can be a lot of confusion as to how to shape up, the mechanisms for decision making, how to shape up shareholding. Should we give him shares? Should we give him ESOPs? What if he doesn't stay with him? Like we are, the initial co-founders are on one side, the new person is on the other side. That is the kind of thing that happens, right? So these issues need to be tackled very, very well. There are also cases where, as someone rightly pointed out, where there are two co-founders in two different countries. And now they are supposed to do work in two different countries altogether. Okay, like one is in Singapore, another is in India, one is in US, another one is in India. Like that, there are people who have co-founders in different jurisdictions, and they are supposed to look at work in different jurisdictions also. So now, what do we decide? Should we make this agreement enforceable in India? Should we make this agreement enforceable in the US? Should we decide to have it enforceable in Singapore? What do we do about it? Or how do we work through it? Okay, because it is possible that the company can be located in one jurisdiction, but a lot of work is being done in another jurisdiction. So how do we shape these clauses? That question can also come out. Dispute resolution mechanism is also sometimes something which people are concerned about, that whom should we bring in? Should we bring in mediators? And, should we both have to agree? So people do decide that, okay, we will bring in someone who's been in this industry for a long period of time, whom both of us regard very well, and we'll consider that person as a mediator, and we will proceed on that basis. Most people prefer informal mechanisms rather than actually going even through arbitration or even through legal proceedings, right? They put it as a last resort. It is there in the agreements, but usually they put it as a last resort when nothing of the sort before works out. They prefer informal mechanisms to deal with dispute resolutions in the initial stages. These are other clauses which can work out, which can be there in the co-founders agreement. But as Ramanuj very rightly said, most crucial are clauses if people are leaving or get kicked out of the company, because there is significant amount of confusion about what to do. Like they already hold certain shares. How do we make them transfer the shares back? What if they don't transfer? What happens, or how will we do that? Okay, what is the manner in which we are going to deal with it? This is one area which is maximum painful for people to deal with, and like particularly when people are leaving, that is one thing that, and when new investors are coming in. Now, one co-founder is agreeable to the investment, another is not agreeable to the investment. These decision-making issues can come up obviously when when some new person is coming in, people's shares are going to be diluted, right? So some people,
there is one very important thing that you can do. You can, let's say sometimes there are single co-founders who have started and they are bringing on board other co-founders and they don't plan to give them substantial equity, maybe smaller amount of equity. This is a very common situation, right? Let's say you're running a company and you decided that I want to bring somebody up as a co-founder, but I will give only 5% shares. And they're okay with that. That, yeah, I'll take 5%, no problem. Right? You can decide to give them something called a phantom stock option rather than a actual share in the company. You can give them phantom stock options. Right? I don't want to go into how to do phantom stock options today, but instead of giving shares, you can give phantom stock options to people. It's a real option for you, right? Instead of giving real shares. Okay. So there are a bunch of questions Let's take a few. Komal?
Yeah, I think many people have this confusion on what is the difference between co-founders agreement and partnership deeds or shareholders agreements.
Okay, I will answer that. I have answered it kind of. First of all, you should not enter into a partnership agreement to do any business. Any business. Very bad idea. If you enter into a partnership business, let's say, for example, with me, let's say Komal and I are doing a partnership business, right? I can go to the bank and take a loan in name of the partnership. And if I run away with the money, bank can recover the money from Komal's personal assets. Okay. If you are entering into a partnership agreement, you are taking a gun, loading it with a bullet, handing it to your partner, pointing at your head and say, shoot. Equivalent of this. Partnership agreement is from an era. It's a different era. Let's just say that. Let's just say that if you are entering into a partnership agreement, you are an idiot of first order. And what is going to happen to you, you deserve it. I warned you. Okay? Very bad things will happen to you. I can guarantee it. You can say Ramanuj is a really bad guy saying like this. Right? But trust me, I wish I could use even harsher and more insulting words for you. If you are going to enter into a partnership agreement, knowingly you are putting a gun in somebody's head and saying, shoot me. Okay. Got it? Anybody has a partnership agreement over here? Now to nobody will say anything. Anybody thinking of entering into a partnership agreement? After what I have said, nobody is saying that they have partnership agreement. Okay. Do not enter into a partnership agreement. If I am a lawyer and a client comes to me and says that draft a partnership agreement, I'll be very happy. Oh, nice, nice. Agreement to just start. Next, what will happen? I'm going to make a lot of money from this guy. If I'm a bad lawyer, right? Why you want to enter into a partnership? Never do that. Plus, selling a partnership business is also very difficult. If it is if you enter into a, at least do an LLP. But why LLP? If you do more than 1 lakh revenue in a month, please go and make a LLC or LLCs in the US. But in India, you should at least make a private limited company. Many advantages to private limited company. Limited liabilities there. I mean, I don't want to get into why private limited company is better. That we can maybe discuss another day. But clearly do a private limited. You can raise investment easily. You can sell the company. You can sell a part of the shares. You can take the shares and get a loan from the bank by pledging the shares. There are many things you can do. In which case partnership is useful. Partnership is useful. One is if you are feeling suicidal, you have a lot of money to throw away, you want to destroy your reputation. That is one very good situation when you should do partnership. Another situation is that doesn't apply anymore. There was a time it used to apply. Sometimes there will be like a temporary business. You are going to do a business for the next 7 days and then shut down. Next 7 days, there's an opportunity to start a food stall in the local, whatever. There is something happening, some mela is happening, some fair, something is happening. You have to set up a stall for 7 days. There you can do partnership. No other scenarios. Okay.
Someone is saying effective rate of taxation in companies 45%. No, I don't think so.
No. Effective rate of taxation is not 45%, 25%. And I can tell you, we did 20 crore of revenue last year, right? And in company, nobody actually shows the profit. You can make losses. You book expenses next year. And you can do that so that you don't make profit. If you made a lot of profit, you will have to pay. But otherwise, you can manage in a way that you don't make profit. Nobody makes profits.
Someone is saying DDT, actually no one really distributes dividends in private companies. Like, it is listed companies that will happen, you will get that. But no,
sure, in public limited companies, they do. In like listed companies, they distribute dividends.
Listed companies, it happens.
But I mean, unless your business is like 100, 200, 500 crores, you'll not distribute dividend, and you don't need to unless you're a listed company. When you're a listed company, that's a different scenario. You can't expect me to give you listed company advice right now. It will not be applicable or useful. Okay. So for now, anybody here has a turnover of more than 100 crore in a year? If you have, then tell me, then we will give you advice like that. Otherwise, there's no need. Okay. You should definitely do a private limited company, not even LLP. LLP is okay. LLP, for certain things, it makes sense. But do you really want to discuss all these things? Like, if you're doing a startup, you should not do an LLP. You want to raise investment someday, you want to get acquired someday, then please don't do LLP. Okay? Better to do a private limited company. Right?
So
if you're
someone
doing a
is
startup.
saying, someone is saying, is co-founders, is what is the relevance of declaring co-founders to MCA? It doesn't get declared to MCA. It's not like an officer's designation that you have to make a filing. So you don't have to make that kind of filing or anything with MCA for appointing a co-founder.
So LLP is not that useful if you're a startup. LLP is useful for more like law firms, CA firms, architecture firms, or if I am running a chamber, I am a doctor, I run a chamber and I want to do it in the name of an LLP. Makes sense. Wealth management, sure, maybe. But even there, why not do a private limited company? There is no real benefit of doing LLP, even in wealth management. For EdTech company, definitely do a private limited company. Never do LLP, please. Like, don't even ask. Okay, any startup, right? There is a difference between a service business. I am one or two people or family business. We are running a small service business. That can be LLP. Nothing else. Okay, nothing else. If it is going to be big, if you are going to make it scalable, if you are going to take investment, if you are going to do big things, then definitely private limited company in India. Okay. In the US, C Corp, S Corp maximum, C Corp preferably. Okay. Is it possible that founder of a startup is fired from his own company? Of course possible. Right? Who can fire him? The shareholders can fire him. The directors can fire him. So the shareholders appoint directors. Directors appoint further office bearers. So directors can fire. Shareholders can appoint different directors and fire the CEO and founders. No problem.
Can a co-founder be a designation in a private limited company under an MOU? So this is just like, you give a designation, means they have a right to be called co-founders of the company, and that is.
It is not in the law, right? You can call whatever. You can call somebody Chief Happiness Officer. Nobody will stop you. And you can put the designation in a contract. Nobody will stop you. Yeah. Right? But that does not mean it is recognized under Companies Act. Yeah. Okay. Okay. So we have to proceed now. We have discussed about this. So any other urgent questions I have missed? Not really, right? Okay. So any questions about what clauses should be there? Any of that?
Yes, agreements. Someone is asking, can it be kept getting changed? Yes.
Yeah. You can change the agreement over time, right? So you can 1 year later, you can decide that, you know what, there are certain issues that are not properly dealt with in the co-founders agreement. And if the co-founders all agree, any agreement, if parties agree, they can amend the agreement anytime, any agreement. Parties can decide, you know what, we need to add these clauses and we need to amend these parts of the agreement, and they can amend. So you can amend by consensus. No problem.
Co-founder necessarily need not be a director or shareholder. Yes, they need not necessarily be director.
Need not be. There can be a co-founder who doesn't have any shares. Absolutely possible. Okay.
Someone is asking to share the template. Let me
share the template before they go. Acha, okay. So now somebody asked very important question that, how much do lawyers charge or law firms charge to create a co-founders agreement? In my opinion, co-founders agreement is usually done in the beginning of the company. 10-15,000 rupees for this agreement is a reasonable amount. And a lot of good lawyers, law firms will take 10-15,000 and will create a co-founders agreement for you. Okay. If you want it to be drafted by Komal and Komal's team, they can also do it. We have something like how do I call it? A clinic, a legal clinic. There Komal can do it for you. Komal will charge much less. Komal will charge only 4,000. Correct, Komal?
It is 5,000 actually.
5,000. Okay, sorry, I said it wrong.
But in that, like, see, the way we have done it is that we can book a call first of all for consultation.
Komal, forget it. So basically, it is 5,000 rupees. If you want it to be drafted by Komal, you can get it done. And also there is something that if Komal will not, you can book a call with Komal by paying 1,000 rupees. And that is included in the 5,000. So after the 1,000 rupees, you can get your contract drafted from her for 4,000 rupees. Is there anybody by any chance who want to book a consultation with Komal? If yes, I will share a link right now. Otherwise, it's okay. Yeah, this is for startup, discounted for startup. Anybody interested? Somebody shared without asking me, who is this LawSikho? Okay, we have shared the link. LawSikho has shared. This is the correct link. Whoever is doing all this, next time don't do this. Please leave it up to me. Okay. So LawSikho has shared. You can see it's called lawsikho.com/co-founders agreement offer. I will show you on the screen. Here, this is, by the way, Komal is a very experienced lawyer, has worked in multiple countries, including Ireland and London and India, and she led the listing of India Infoline. So she's a very experienced lawyer. You'll be very lucky to get to work with Komal on something like this. How to create the perfect co-founders agreement with your business partner. Book your calls now, charges increases, whatever. Right? Normally, Komal charges 7,000 rupees for consultation. Offer price today, right now, 1,000 rupees. You can put your name, email ID, country, phone number, and proceed to pay. Okay. And then it will be directed to you some kind of a Calendly link where you can book your slot. That's it, guys. That's the sale that is done. Now I am happy to, and Komal is going to share a co-founders agreement template with you. But as always, we are careful to remind everybody that when you use a template, don't use it mindlessly. And this is something which is important enough that you should spend that 5,000 rupees and consult somebody rather than doing it blindly. Okay, that 5,000 rupees will be well spent. And you can use the template and save the 5,000. I don't have any problem, but it is a little dangerous. So do it at your own risk and don't blame later us that they gave me a template, it did not work and got me into trouble. Okay, keeping that in mind, you can go ahead and use the template. Komal has shared template.
I've shared the link to the template.
You can download the document. I'll open it and show you anyway. Why am I not able to share?
It should click. It's opens when I click it.
So here is the co-founders agreement template, right? I will quickly run you through this. Here is business and ownership, terms and validity of this agreement, responsibilities of the co-founders. Here you have to, this is a very critical clause, tricky clause. You have to write it in the right legal language so that later on there is no conflicts. Mutual rights and obligations of the co-founders, capital contribution and profit sharing, restraint on any other activities, non-compete and non-solicit. We discussed this. So here are the clauses, right? Notices, not a very big agreement, pretty short one. Can be longer, depends.
Someone has a very interesting question that what are the things to remember if I am private limited company and my co-founder tech partner is another private limited company? You are talking of a shareholders agreement in this case, because like companies are not going to be co-founders, they will be shareholders.
Correct. It's a joint venture you are talking about. You need to have a joint venture agreement, not a co-founders agreement. Okay. Where is LawSikho situated? Our office is in Gurgaon. We have an office address in co-working spaces in Calcutta and Delhi as well. But sometimes like our more presence is in Gurgaon, and we're a remote working company. We have employees in 7-8 different countries apart from India. We have people in Pakistan, Bangladesh, Bhutan, Nigeria, Turkey, Ukraine, USA, Canada, multiple countries. Can we have contact number of Komal so that we can connect her later? Yes, Ashish Chimnani. For that, you have to go and make the payment so that you can have a number. We are not sharing numbers just like that. Hey, you can reach out to her on LinkedIn. Komal's, I'll share Komal's LinkedIn, right?
Yeah, I've just shared it. Just said.
Yeah, actually what happens when we do this boot camp, Komal gets flooded with a lot of people calling her, which is why we are not sharing that. But we will share her LinkedIn with you so that you can reach out to Komal if you want, right? In fact, I will share.
Someone is asking, please share the link to pay consultation. So, Pratibha, I think
yes. This is Komal's. Okay, let's do question answer. Komal, any questions we can answer?
I think we have taken most questions even from the questionnaire. Even from the Q&A, most questions we have taken.
I have also shared my LinkedIn. If you want to connect, ask any questions, do that. Stay in touch. Please connect with me on Twitter also. That is very important. Let me share my Twitter with you. I'm more active on Twitter than LinkedIn. So you can DM me on Twitter also. My DMs are open on Twitter. You may not be able to send me a free message on LinkedIn, but you will be able to always send me a free message on Twitter. So do that. Making agreement using hello sign is valid. Yes, it is valid.
Yes, it is valid.
No problem. You can do that. What's better to have, a tech co-founder or a CTO? Vishal, it depends. You're asking, is it good to earn $1 million or $1.5 million? For me, it's like, both are good, really good. As long as you have a CTO or a co-founder, both are good. And having a tech co-founder is really, really good. But if you cannot find a tech co-founder, then have a CTO at least. Asking in terms of dispute. I mean, there won't be any dispute because there's a tech co-founder or a CTO. That won't matter. Disputes will be there. And if you have a good co-founder agreement, there won't be any dispute. Please share the recording in WhatsApp group. Yeah, we will upload it on YouTube and then we will share. Okay. Somebody is asking for the payment clause, that offer page once more. Just share.
Yeah, let me share that.
Shared. Offer page is shared. Okay, guys. It seems there are no more questions. It seems we have answered all the questions. So if there's a question, still copy paste. If I have missed some question before, please copy paste it again. If my startup is a side hustle and can't make private limited because of a job, what is the next best option? Look, your job can prevent you from working in another company, but it cannot stop you from holding shares in a company. So if you have a side hustle, start a private limited company. It will not be a problem in your job. Aroy, you can start a private limited company and you will be a shareholder in that company, right? And if not, you can always have some nominee shareholders. So for example, you can have your mother or sister or your wife be the shareholder in your place. And then you can have a back-to-back agreement with them that 5 years later, they will transfer the shares to your name. You can do that.
Yeah, we've dealt with cases like this.
Correct. If you have such a situation, talk to Komal. She'll help you out. Very easy to solve this problem. WhatsApp group. Acha, I have a Telegram group. I don't know about WhatsApp group. I have a Telegram group that I manage for startup founders. You can join that if you are not a part of that already. I'll share it in a moment. 1 second. Just copying it. Here it is. Okay. If you cannot find this if the link is not working or whatever, then go to Telegram and look for startup founders and you will find it. And I will share the link of this session in this Telegram group. WhatsApp group, I don't know if we have. Do we have a WhatsApp group also? Komal, I am not even aware that we have a WhatsApp group for startup founders. No, there is no WhatsApp group. Join
WhatsApp group नहीं create किया है.
आपने create किया है?
नहीं, WhatsApp group नहीं है. Telegram
नहीं है. हाँ. Telegram है. Telegram में join कर लीजिए. Telegram group is there. We will share the recording of this session there. Can you please put light on co-founder with investment part? If there is an investment part, you write it down in the co-founders agreement. Also, in that case, your co-founder agreement won't be such just 3-4 pages. By the way, the template Komal gave you, it is too short. There are a lot of other things. I think Komal wants you to consult her, so she did not give you a good draft.
No, but it is a very basic template.
But yeah, it is a very basic template and you need a longer version, especially if you're putting in money, right? A bunch of other rights and things needs to be written down properly. Fee particular 1,000 for consultation and 4,000 for drafting the agreement. 5,000 total, 1,000 plus 4,000 total, 5,000. Consultation 1,000, drafting 4,000, total 5,000. Correct, yeah.
You help with IP as well? Yeah.
Yes, Komal loves IP. It brings a smile on her face. You will not find too many people when they hear the word IP, patent, trademark, licensing, they think it's boring. Komal smiles year to year. So you can understand, you can totally rely on her for these things. You can non-disclosure agreement by part. Yeah, you non-disclosure will be a clause in your co-founder agreement. You don't need to sign an entire agreement for that. Non-disclosure will be one clause in your co-founders agreement. Can an idea be patented? No, it cannot be patented. Only a application, a physical manifestation of it can be patented. What is the previous message, Aman Kumar?
Regarding working as a part-time?
What? Just copy paste the question. There are so many questions you miss out. Can you help me to create agreement with my technical team? Yes, Manish, go ahead and book the consultation. Talk to Komal. She'll help you. Absolutely. No problem. Can family members be part of shareholding? If the founder is putting all the money, yes, it's your money. You decide who else you want to be shareholder. So if I am buying, let's say 10% of a company and I'm paying 50 lakhs for it, I can decide that 5% I will be in my name, 5% will be in my mother's name, or 2% will be in my father's name, 3% will be in my mother's name. That's up to me, no problem. My money, my rule, right? Is the process to convert LLP to private limited a hectic one? Yes, it is a hectic one. Just go and start another private limited company and transfer all. Don't even convert. Don't even bother to convert. Not necessary. People do this in US. There it is easier. In India, it's easier to just start a private limited. It may be necessary to convert sometimes, but not always necessary. Okay. Durgesh Patni, Sangeeta Patni did not understand how one can have co-founder without shareholding. Okay, so if you can sign an agreement with someone, there are two things. One is that you can give them a respect of a co-founder without giving them any shareholding. It is possible, right? Why not? It's written in your agreement that you will be a co-founder, but you will not get any shares. There's no problem with that. Second, it is possible. Second, there is no law that prevents it from happening. Second, the co-founder may not agree. That's a different thing, but possible. Second issue is that you can give them PSOPs, something called a phantom stock option, which is not a real share. It gives you the same economic benefits like holding a share, but you have no governance right, no voting right, nothing. So you can give PSOPs to people instead of actual ESOPs or actual shares. You can give them something called a PSOP, phantom stock option, right? You can do phantom stock option from the beginning also, provided the other person is ready to accept it. Please switch the screen.
Yeah, I can't understand what is switching.
How do I switch the screen? Maybe you like this screen better. Okay. What else, guys? Any other question we are hearing? Right now, to consult us, there is no charges. You can just ask questions. So ask. Aman's question. What is Aman's question? Is changing the name of the company a good idea? You can change. There is no problem. It is possible to change. No problem. A lot of work, but possible. Aman Kumar's, can you find Aman Kumar's question? Komal?
Yeah, I'm trying to find.
Can a person already working in a company start a private limited? Yes, Abhishek, yes, you can. No problem. Muhammad
I'm looking forward to join another company while working as a part-time co-founder. I've seen people do that, but can you elaborate more on clauses and other things?
So basically you are saying that you are working in one company already or planning to join another company. You are basically working in another company as you. Now you want to be a part-time co-founder in some new company that you are starting. Is it possible? Yes, it is possible. How do you do it? In the co-founder agreement, all that will be written. That you are already working somewhere and you will ensure that you will not mix, you will never put the company in any IP related conflict. You have not signed any agreement with the other company that prevents you from doing this, blah, blah, blah. All these clauses have to be written. And you can, the co-founders can agree that, you will be working at least 2 hours every day or 4 hours every day or 40 hours in a month, whatever it is. You can decide all those things and write in the co-founders agreement.
He's saying it is vice versa. Then then whatever is in your existing co-founders agreement will govern your relationship, Aman. If you want to take a job elsewhere, you want to exit that relationship, co-founders relationship, and take a job elsewhere, then it will be governed by whatever is provided for in your existing agreement. Right?
Do you help with doing valuation of startups for fundraising? What would be the fees for the same? No, we don't do that, right? You do that. Do you do that also?
We don't do, but we can recommend people.
We can connect you with somebody if you want.
We can connect you with people.
Till the time the company is listed, the stocks and shareholding are just numbers on an agreement, right? Right, Vishal, correct. Because these can't be converted into monetary value during the startup. No, it can be. Like sometimes the startups are the buyback. Sometimes there will be another private shareholder who will be willing to buy your stake. That happens, right? Sometimes you raise investment. And if the private company is making money, right? So imagine the private limited company is making 100 crores, right? So if you're controlling some shares of that, it certainly has a value. It's not like there's no value. What is CSOP? I don't know CSOP. Never heard this before. ESOP I know. Employee stock option plan. Employee stock option plan is ESOP. PSOP is phantom stock option plan. CSOP I have never heard. If you know, please tell me. My question was case prior to any investment. Vishal, in my company, there is no investment. But if we are doing good revenue every month, do you think our company's share has no value? We have no investment, but there is real revenue. Correct? It is growing. Of course, there is a value. In that case, existing company where the person is working, can they take legal action on the person as their co-founder in another? So that depends on Abhishek, what agreement you have signed with that company, right? Depends on that.
Aman, again, it will be governed by whatever are the provisions in your employment agreement with that company, right? It will be see in here, if you have everything sorted with your co-founder here, and if you're looking to take a job somewhere, then and you will have to tell them, right, that you are already working as a co-founder somewhere. So it depends on whatever is provided in your employment agreement there and how comfortable they are. If both the parties are comfortable, then you're fine. You're sorted. Nothing else.
Okay. We are a social media startup and we are not making any transaction for the coming 6 months at least, since we are at a very early stage. Is it right time to register as private limited? Do you want to raise money in just register now? If you are not sure this company after 6 months will continue or not, then don't. Otherwise, set up private limited, right? You're going to make a social media, your big plans. Might as well create a private limited, and private limited will be useful also. Even if this company shuts down, you will be able to use it for a different purpose. Your next company, right? Community stock option pool are options which have the same financial right as equity shares, but no voting rights. CSOPs do not come on the cap table and are fastest to execute. Okay. Sounds like PSOP only. Like phantom stock option. What is the average cost of maintaining a private limited in a year? Abhishek is asking. What do you think, Komal? I think it's around 10,000 or maybe 6,000.
No, you will have to get audit completed, and also there may be some filing. So it depends on like how much you are able to negotiate.
Audit, so if you have a lot of revenue, right? Audit is not for every company, is it?
Not for, but so it will depend upon what is the kind of work or what is the kind of level.
Let's say the revenue is 10 lakhs in a year. What will be the cost?
Again, like
minimal cost. I know people who are getting it done in 6,000, 10,000, right? And they have almost very negligible, just almost a shell company kind of situation.
It will not be 40, 50,000.
No. 5, 6,000, 10,000.
Right.
I mean, sure, there are CAs who will take 50,000 for doing that.
There are CAs who will take like crazy amount of money, but
so that is like for anything. I'm saying on the lower side, the minimal, right? Yeah, Aman Kumar is saying I am getting it done for 15,000. That is reasonable, right? If Aman really goes and looks hard, finds somebody a little junior, might be even 5,000, 6,000, you know. But not necessary that, 15,000 is pretty decent, I would say.
Manish is asking what is the costing of NDA, privacy policy and employment agreement.
Setting up private limited is so very cheap. All this Vakil search and all these people do it very cheap, no? Komal, right?
Yeah. I mean, like, see, setting a private limited, government fees are nothing at all. It is all on how much you negotiate with the professional to certify.
Professional also will do it for like 5,000-10,000. Many people will do it.
Yeah.
Do you do it, Komal? Your team does it?
Yeah, we can get incorporation.
How much do you charge for this?
Depends on what you
अरे यार depends on मत बोलो यार, छोड़ो तो आप रहने दो, ठीक है? Okay guys, thank you very much. Gotta go. Take care everyone. Bye. Komal, any parting words?
No, people are saying no.
अरे क्या है भाई, अच्छा बोलो. अच्छा कुछ questions और भी है क्या? अच्छा बता देते हैं.
He's asking the same thing. What is the costing for NDA? Manish, you reach out to me on LinkedIn. I have shared my LinkedIn link. Okay.
Or reach out to Komal on LinkedIn. Reach out to me on Twitter. I'll tell you.
Okay.
All pricing inquiries today. Everybody is like, बाकी सब बोल. Can we make an intellectual property agreement with our employees, or is it a non-disclosure agreement? You sign an employment agreement with your employees, Vishnu Das Krishna, and that in that employment agreement or consultancy agreement, you will have intellectual property related clauses, confidentiality related clauses, everything. But it is an employment agreement that you sign. Okay.
Great. An arbitration clause be inserted in co-founders agreement? Yeah, you can. Why not? It is an agreement between two people. You can decide how you want to resolve your disputes.
Is it mandatory to get an audited balance sheet for private limited company annual revenue around 6 lakhs? I don't think so. इतना कम पैसे में लगता है क्या? Audit करना पड़ता है?
I think it is mandatory.
Okay, sorry, it is mandatory. If Komal is saying she's right. What is cost? What is the costing of NDA, privacy policy, and employee agreement?
Yes, that is money.
Okay, that you reach out. ऐसे ही मतलब assume like around 4,000-5,000 per agreement. Going for private company, how much revenue is required? Is there any limit? No, there is no limit. You can have zero revenue and still have a private limited company. What is the cost for EdTech? What is the cost of what?
It is mandatory for even if there is no to register as a private. Okay, cost to register as a private limited.
When we are going to
this, right?
We actually do one session every month, some topic or the other for startup founders. So stay in touch. Next month we'll do one more sometimes. I am thinking next time we'll do term sheet negotiation. Or what have you decided?
Yeah, we are looking to do. That is something we can get a spoiler alert here. We are looking to do term sheet negotiations in the next month.
Good. Term sheet negotiation we'll do.
Great. Okay, I think
good question. If there is no revenue, do we still need to file tax returns? You can file nil returns. You should file.
You have to file nil returns.
You can respond on Telegram group. You can comment on every post, Vishal. You can comment under any post. We'll see. Or you can send me Twitter DMs. Most welcome. Can an arbitration clause be inserted into co-founder agreement?
Yeah, we said that.
Of course.
You can insert whatever method of dispute resolution you want. We can.
Okay, guys. Take care. Bye. Take care. See you. Good night.